Hello, I am Janae Nelson, President and Director Counsel of the Legal Defense Fund. I'm delighted to welcome you to LDF's annual SCOTUS Roundup. The focus of today's discussion will be the civil rights cases that were before the U.S. Supreme Court during the 2023-2024 term, including cases in which LDF was involved either as litigants or friends of the court. The decisions in these cases will ultimately affect all of us, either directly or indirectly, and their impact will be felt acutely by the Black communities that LDF serves. You will note that many of the cases you'll hear about impact both the future and quality of our democracy, the guarantee of equal rights, and the freedom from discrimination. With such critical matters on the line, we believe everyone must be informed and engaged, which is why I want to personally thank you for attending this webinar and for standing with LDF as we fight for racial justice and for equality for all. In recent years, the conservative supermajority of the current Supreme Court has repeatedly upended decades of precedent and issued several rulings that have started to fundamentally shift our democracy. This follows a period of growing retrenchment from rights and protections dating back to the Shelby County decision, which gutted the Voting Rights Act over a decade ago. Our Supreme Court is failing us. Instead of righting past wrongs, this court is removing the very protections we need as our society becomes more polarized and as basic rights such as education and voting, are politicized. The language of justice is being weaponized against those who it was intended to protect. During this past Supreme Court term, the court once again issued several rulings with the potential to disrupt democracy by uprooting widely accepted precedent. Our collective response to these decisions will impact the trajectory of our democracy and determine its ability to survive. Our actions to limit the destructive effects of a near total presidential immunity grant, crippling of the administrative state, an assault on reproductive rights, and the ceding of redistricting to political operatives at the expense of Black voters will decide whether we will be a nation that lives up to its full potential as a multiracial, multi-ethnic, inclusive democracy, or whether it will fail. It is in these moments of precarity that there is opportunity to confront our structural frailties and transform our laws and systems to deliver justice that our Constitution and other laws have never fulfilled. As we commemorate the landmark victory of Brown versus Board of Education, which ended state-sanctioned segregation in America, we at LDF are reminded of the extraordinary power of the Supreme Court to transform this nation against its will for its own good. We are far from that moment in terms of the direction of this court, but close enough to LDF's victory in Brown to know what is possible when people and the power of law unite to confront even the strongest headwinds. Although attacks are coming from all directions, I'm confident we can meet these challenges, but we can't do it alone. We need your continued support more than ever. So thank you again for joining us and for the different ways you bolster LDF's mission, whether it's providing financial support, attending our annual National Equal Justice Awards dinner, taking a public position on civil rights issues, or ensuring your organization advances racial justice and equality through its internal policies. Your generosity enables our growing staff to continue the fight. And now it is my pleasure to introduce you to one of those staff members, Sam Spatal, LDF's Director of Litigation and General Counsel. Sam leads our litigation docket across LDF's 4 pillars: education equity, economic justice, criminal justice, and political participation. Sam also supervises LDF's appellate litigation in the Supreme Court, federal circuit courts, and state Supreme Courts. He has drafted or contributed to over 50 Supreme Court briefs since joining LDF in 2017. and he maintains an active docket of his own cases, including several high-profile criminal justice, voting rights, and education matters. As general counsel, Sam also supervises in-house legal issues for LDF. He will moderate our discussion today. I hope you enjoy it, and many thanks again.
Thank you, Janae, and thank you everyone for tuning in today. I'm delighted to facilitate this conversation about key civil rights cases that the Legal Defense Fund participated in the 2023-2024 Supreme Court term. We're going to begin by talking about two redistricting cases in which LDF represented parties before the court. For those of you who are not as familiar with it, redistricting is the process by which states and local governments redraw the lines for their electoral districts. Redistricting requires an accurate population count, and it occurs every 10 years after the census. When it is conducted fairly, redistricting accurately reflects population changes and racial diversity, and it is used by legislators to equitably allocate political power and fair representation. But when politicians use the redistricting process to manipulate the outcome of elections, that is called gerrymandering. And gerrymandering undermines our democracy because it suppresses the voices of voters. We're going to begin by talking about a case called Calais versus Landry. Calais has a very complicated history, which we're going to hear more about. But essentially, it was a response to a different lawsuit that LDF filed, along with other organizations on behalf of voters, after the 2020 census. In that suit that LDF litigated, we showed the courts that the Louisiana legislature discriminated against Black voters in the first congressional map it drew after that 2020 census. As a result, the Louisiana legislature created a new map with a second majority Black district. Then, in response to this new map, a new suit was filed on behalf of voters who described themselves as non-African American voters, trying to prevent this remedy that we had achieved. We're going to be hearing about that in just a minute. We're also going to be hearing about the Supreme Court's decision in another key LDF case, Alexander versus the South Carolina chapter of the NAACP. In that case, the Supreme Court disregarded decades of its own precedent, and it limited the kinds of evidence that plaintiffs can rely on in showing racial gerrymandering occurred in the districting process. After we talk about these two major redistricting cases, we're going to talk about cases where LDF filed amicus briefs over the last term. Amicus briefs, also known as friend of the court briefs, are briefs that are filed not by parties to a case, but by others who have an interest in the case. And they're an opportunity for others to present the court with facts, issues, and arguments that should inform the court's decision-making. LDF files a number of amicus briefs every term in key civil rights cases. We're going to hear about several briefs that LDF filed last term, including in cases Trump versus Anderson, which concerned the effort by Colorado to remove former President Trump from the ballot because of his role in the January 6th insurrection. Muldrow versus City of St. Louis, which is an important employment discrimination case. And then two cases involving reproductive rights. One, FDA versus Alliance for Hippocratic Medicine, and then consolidated cases involving the application of a federal law called EMTALA in the state of Idaho. I'm going to now turn to introductions of two senior members of the LDF litigation team who are going to walk us through the redistricting case. Leah Aden is a senior counsel who joined LDF in February of 2012. During the post-2020 census cycle, Leah led the planning, strategy, and supervision of LDF's redistricting challenges to discriminatory state and local maps in a number of jurisdictions, including in Alabama, Louisiana, South Carolina, Illinois, and Mississippi. Leah is also our lead counsel in the Alexander case, which is the challenge I mentioned earlier involving harms that racial gerrymandering in South Carolina's congressional maps caused to Black voters. In October of 2023, Leah argued that case before the United States Supreme Court, seeking to defend the district court's decision, recognizing that South Carolina had engaged in an impermissible gerrymander. In so doing, Leah became one of a very small number of Black women who have argued before the United States Supreme Court. She's going to tell us about that case today. I'm also delighted to be joined by Stuart Nafee. Stuart is the manager of LDF's redistricting project. Like Leah, he is one of the nation's preeminent voting rights litigators. He has litigated a number of voting rights issues. In his current role, he works to ensure that districting lines established in the wake of the 2020 census protect and enhance the voting power of Black communities. He has also litigated, among other voting rights issues, challenges to aggressive efforts to purge voter rolls and other forms of voter suppression. And he's worked to secure compliance with another very important federal voting rights law, the National Voter Registration Act. Stuart leads our team in the Calais case that I mentioned earlier, the case challenging the congressional map that was enacted as a remedy as a result of this earlier suit that LDF litigated. I think we're going to start with Stuart, who is going to tell us a little bit about Calais versus Landry. And Stuart, this is a pretty complicated case, so maybe if you could sort of just set the stage generally, what is this case all about?
Thank you, Sam. I'm very happy to be here, and thank you for the opportunity to discuss Calais v. Landry. So Calais is the latest chapter in the ongoing fight to secure fair maps in Louisiana. So as Sam mentioned, in January of this year, the Louisiana legislature enacted a new congressional map that included a second majority Black district, making 2 out of 6 districts in a state that is a third Black. And as Sam also mentioned, this map replaced the one adopted in 2022 after the 2020 census. That map had only 1 majority Black district, as had been the case for decades in Louisiana. So the new 2024 map came about as a result of LDF's successful litigation under the Voting Rights Act challenging that earlier map. That was a case called Robinson v. Landry. And the state did not, in 2024, the state drew a new map, as I mentioned. The state did not draw a map that looked like the one we proposed in the Robinson case. Instead, it drew a map that stretches diagonally across much of the state. This was an act of realpolitik. It was the result of a vindictive governor's desire to punish a political rival by placing him, rather than a favored congressional incumbent, in the new majority Black district. In the Calais case, a group of white voters sued the state, arguing that the 2024 map is an unconstitutional racial gerrymander because it divided voters into districts based on race. Now, to understand how this claim can even survive the laugh test, let me explain the somewhat complicated interplay of the Voting Rights Act and the Constitution. So the Voting Rights Act is a federal law. It requires states to take affirmative steps to ensure that their redistricting maps don't dilute the votes of voters of color by packing them into too few districts, limiting their electoral strength in others, or by cracking them across many districts and preventing them from having an influence in any. So to ensure this doesn't happen, states have to pay attention to race to some extent when drawing the district lines. Now, on the other side is the Equal Protection Clause of the Constitution, part of the 14th Amendment. And at least as that part of the Constitution has been interpreted by the Supreme Court, it means that states must be race neutral and cannot use race to place voters into districts without a strong justification. So this creates something of a conundrum for states. The Voting Rights Act says states have to use race to draw district lines to avoid vote dilution, but the Constitution says they can't use race to draw district lines without justification. In the Calais case, the white plaintiffs are saying that the state used race to draw district lines and didn't have an appropriate justification. We intervened in the Calais case on behalf of the clients that we represented in the Robinson litigation, and we argued to the court that the state did have a justification for using race because it had to comply with the Voting Rights Act and it had to comply with the decisions in the Robinson litigation. And so therefore the use of race, to the extent race was used in the 2024 map, was justified.
Thank you, Stuart. So you talked a lot about this Robinson case that LDF litigated, which set the groundwork, so to speak, for the Clay case. Can you tell us a little bit more about the Robinson case and the evidence of discrimination that you and our colleagues were able to demonstrate had the Louisiana legislature had been engaged in as a result of that Robinson litigation?
Okay, well, let's step back for a second. So this litigation and the fight for a fair map for Louisiana's congressional districts has really been a roller coaster ride. And really, it started back in the 1990s, which was the last time Louisiana tried to expand representation for its Black citizens. But we won't go that far back today. So we'll start with 2022, when the legislature passed its first congressional map after the census. And as I mentioned, that map had only one majority Black district, which meant that only one candidate preferred by Black voters could ever be elected to Congress. No Black candidate or any candidate that Black voters supported had been elected in a district that was not majority Black in Louisiana. And that's despite Black voters making up a third of the state's population and having distinct candidate preferences from the white majority. So after the 2022 map went into effect over the veto of Governor John Bel Edwards, we sued under the Voting Rights Act. That's the Robinson case, as I mentioned, and as Sam was just referencing. So in Robinson, we argued that the state had packed voters into a single majority Black district. It was a district that combined the city of Baton Rouge and the city of New Orleans, two of the largest population centers and the largest Black population centers in Louisiana, into a single district. And we presented evidence showing that a different district could be drawn, that two districts could be drawn, one based in New Orleans, as had always been the case, or had been the case since the passage of the Voting Rights Act, I should say. And then the second based in Baton Rouge, and then extending up the Mississippi River to the northeast of part of the state. And we showed that district, was consistent with how the state had drawn districts in the past and kept communities of interest together. So kept Black populations together that had common interests, shared interests in access to healthcare, shared interests in access to education, and a shared experience with, for example, the criminal legal system. And so they were appropriately drawn together in the district. And we also showed that without drawing a second majority Black district, as I mentioned, Black candidates would never be able to win election to Congress. And Black voters would be perpetually underrepresented in the congressional delegation in Louisiana. So as I mentioned, we filed litigation. This was in March of 2022. And we asked the district court for a preliminary injunction. So basically, we asked for a temporary map for 2022, for the 2022 congressional elections, while the case went forward. But before the 2022 elections could happen, the Supreme Court put our case on hold while it considered the Milligan case, which was on appeal from Alabama. That's another of LDF's redistricting cases that went up to the Supreme Court in 2022 and resulted in a favorable decision in June of 2023 that I'm sure many of you are aware of. That meant that the 2022 map, that the hold that the Supreme Court put in place in our Robinson litigation, meant that the 2022 map that diluted Black votes, the one that the legislature enacted in early 2022, was used in the 2022 elections. And again, the result was one candidate preferred by Black voters, was elected to Congress from the New Orleans-based district. So then after Milligan was decided in June of 2023, the Supreme Court unfroze our case and sent it back to the lower courts. The state dragged its feet on implementing a temporary map while the preliminary injunction was on appeal. So, trial hadn't happened yet. Nothing had happened except preliminary injunction, which we were successful in seeking in 2022. And that was on appeal. We won the appeal in late 2023, and the state at that point saw the writing on the wall and decided they were not going to continue fighting the case that they knew they were going to lose after having lost at the trial court and then at the Court of Appeals, and effectively also at the Supreme Court when it sent the case back after Milligan was decided. So the state decided they'd rather draw the new map themselves instead of having one imposed on them by the courts. So that takes us to January 2024, when, as I mentioned, the legislature finally gave us a map with a second majority Black district. Our clients and Black voters in the state were thrilled, and we thought we had secured Black voting rights at least for the 2024 cycle, knowing that, there might be challenges in the future. The decade is, almost halfway over, but this, as we've seen in past redistricting cycles, sometimes redistricting litigation extends through the entire decade. But we thought we were safe for 2024. And then came the Calais litigation. So as we have seen more and more often recently, the plaintiffs filed Calais in a very conservative district. We defended the map. We explained to the court that the Robinson litigation had instructed the state to draw a second majority Black district, and the state was complying with that decision. And even though the district that the state drew didn't look like the ones we had presented in the litigation, it was justified because the state needed to comply with the Voting Rights Act, and to do that, it needed to draw a second majority Black district. And it had its own reasons. The legislature had their own reasons for drawing a different district. As I mentioned, there was a lot of political negotiations and political shenanigans, you might even say, going on that led them to draw that district. Issues, shenanigans, and negotiations that had nothing to do with trying to pack voters into districts based on race, but instead had to do with politics. But the court agreed with the plaintiffs, and it said that the diagonal district that the state had drawn was race-based and couldn't be justified by the need to comply with the Voting Rights Act, because the Voting Rights Act cannot require drawing districts that, just from looking at them, don't make any sense. And that's how the court saw the district that the state drew. So that ripped the rug right out from under us. Our new district was here and then gone. We appealed and asked the Supreme Court to stay the district court's decision and restore the 2024 map, the same thing they had done when we were the plaintiffs in the 2022 litigation, in the Robinson litigation. We went out of our way to point out that it would be inconsistent if they were to say that, when Black plaintiffs challenge a map, they have to wait for the appeal to be decided before they can have their new map, but white plaintiffs don't. And ultimately, and just in time for LDF's annual gala, the court agreed. A gift from Justice Alito to Janae for her to present to our supporters at our annual gala. So for 2024, we now finally have a map for Louisiana's congressional elections that includes 2 majority Black districts.
And as a sort of coda to explain where we are in terms of next steps, so as Stuart has said, the Supreme Court has made sure, as a result of blocking that negative district court decision, that there will be this fair map in 2024. There are next steps in the Supreme Court where we will be filing a brief asking the court to consider the case on the merits and to address on the merits this unfavorable ruling from the district court. Now that we've had an opportunity to talk about Calais and Robinson and this really remarkable litigation success in Louisiana, I'm going to ask Leah to join us to talk about the Alexander case. Leah, can you start by telling us just briefly, what is Alexander all about? What are the key issues in that case?
Thank you, Sam. Hello, everyone. Alexander is about the racially discriminatory map that South Carolina passed after the 2020 census. The congressional map in particular that the legislature passed had many flaws, but the one that was before the Supreme Court in Alexander relates to how South Carolina moved more than 30,000 Black Charlestonians out of Congressional District 1, which is essentially the congressional district that runs along South Carolina's coast, and how the movement of those voters isn't explained by the state's respect for its own traditional redistricting principles, such as keeping the heart of counties or counties whole. It's not explained by keeping districts contiguous or other redistricting principles. And through evidence, it also is not explained by mere partisanship. Essentially, Black Charlestonians were not moved because they were Democrats. We showed evidence that they were moved because they were Black, and that it wasn't just Democrats being targeted in the redrawing of South Carolina's congressional map. We challenged that movement on the basis of two constitutional claims. So this is not a case brought under the Voting Rights Act. This is a pure constitutional claim. The first claim is that movement was a racial gerrymander, that race was the primary means by which voters were moved, and there wasn't a good reason for excessively using race in the movement, such as trying to comply with the Voting Rights Act. And the second distinct claim was that the purpose of moving those voters and others was to harm the electoral power of Black voters in South Carolina's congressional map. We were able to convince a 3-judge panel unanimously that those constitutional violations had occurred, and the Alexander case is South Carolina's appeal to the Supreme Court of both of the favorable rulings that we got on those constitutional claims. Unfortunately, after trying to get the Supreme Court to not take up the case because we thought that the findings of the district court, both legally and on the facts, did not warrant review by the Supreme Court. We lost on that. The court took up the case on the merits. After oral argument in the fall of 2023, we got a decision 7 months later, and the Supreme Court, very shamefully, in my opinion, and very erroneously, rejected the findings of the district court and really defied its own precedent, including taking the dissent from a 2017 case in which a racial gerrymander had been found in North Carolina, taking the dissent and having that dissent become the majority and the lens by which they viewed our case, and then viewed our case as having been a failure in terms of our constitutional claims. So that is essentially about the harming of Black voters in South Carolina's congressional map under a constitutional theory. And I think one of the things that is important about the case and why it does matter, and why I think was really motivated to pursue the case, is because we do have the important protections of the Voting Rights Act to create ability to elect districts for Black voters. But in the absence of such districts, and in the absence of the Supreme Court policing partisan gerrymander, after the 2010 census, South Carolina and other states have elected to harm Black voters because they think that there are no protections. And we believe that the Constitution protects the type of harm that happened in South Carolina and has happened in other places. And that is why it was worth raising these claims, even though we have been unsuccessful in this case after Supreme Court review.
Thank you, Leah. And thank you also for explaining how the Constitution and the Voting Rights Act interact with each other. The Voting Rights Act is, as Leah explained, an incredibly important and powerful tool that allows us to fight for fair maps, but it has certain requirements that may not be able to be met in certain jurisdictions, like in South Carolina, including there's a requirement about the size of the Black community or another community of color that is looking to draw potentially a new, as Leah described it, ability to elect district. And so in places where there are not enough Black voters or other voters of color to allow the creation of a new majority Black district, then we have to turn to other tools, which Leah and the team did so persuasively in this case, and unanimously convinced this 3-judge panel. And then, unfortunately, as Leah said, the United States Supreme Court, from our perspective, was not fair in applying its own precedent when the court decided to reverse that decision. But there was a very strong dissent in the Alexander case from Justice Kagan, joined by Justices Sotomayor and Jackson. And Leah, could you talk a little bit about what the main points of disagreement were between the dissenting justices and the majority, and why, I think from our perspective, the dissent really had the much better of the argument?
So, in the most basic way, plain way that I can think about saying it, the dissent tells the truth about what happened in South Carolina's redistricting, and it tells the truth about what the factual trial record was below. And it applied the rules by which we thought were governing racial gerrymandering cases at the time that we brought our suit and at the time that the trial court issued its decision in January of 2023. And the dissent talks about the burden, the very hard burden that we had to prove a racial gerrymander, and said that that they have their perspective as the Supreme Court is to review if there are legal errors and then to review whether they're factual errors, and if they're and that they're with factual errors there or with the factual record, there's supposed to be great deference to what the trial court did. And so it said maybe from our vantage, we would have decided differently, but that is not our job. Our job is to respect the factual findings of the trial court. And they did not see that the trial court committed a legal error. So I think the dissent is powerful in the sense that it is a record of what actually occurred at the trial court level. And I think it's an actual it respects the role of the trial court, and it respects the precedent that was in place prior to the majority's six majority decision. By contrast, I think the majority, they essentially take a lot of the dissenting views from the 2017 Cooper case and make them the majority. There are some cases from the 90s that also dealt with the interaction between race and party, and some of those dissenting views, I think, have become now the majority. They have elevated and sort of given a supercharged deference to state legislators that that their actions should be presumed to be acting in good faith, and that there's a heavy burden for us to overcome them. And I think that this decision also highly elevates the role of partisanship and sort of legitimizes partisanship as a justification for line drawing, even though there is still theoretically a way for us to show that you can, even if you're pursuing partisan goals, if you're harming Black voters as a means to get there, or using race as a proxy for partisanship, that the Constitution still protects it. But the court has sort of elevated the role of partisanship and allowed states to hide behind partisanship to the detriment of Black voters and other voters of color. So I think it's a very bankrupt decision, to be fair. I think it's disrespectful to the trial court. It's disrespectful to its own precedent, and it has elevated the burden. But I think the one thing that is worth impressing is that I believe, at least at the Legal Defense Fund, we look at the facts in every jurisdiction and we identify what the best tool we think is to challenge racial discrimination. And while in one jurisdiction it might be the Voting Rights Act and or the Constitution, the Arlington Heights intentional discrimination theory, in another jurisdiction it may be a racial gerrymandering theory, and that we will use the best tool that is available to us. And while the Alexander decision is disappointing, shameful, wrong, we will have to decide jurisdiction by jurisdiction whether that claim is the one that should be brought or some other claim to challenge racial discrimination, and that everyone should be looking at jurisdictions and the very specific facts to determine like what is the best course of action. So Alexander definitely is wrong. It definitely, I think, changes the burden, puts the thumb on the scale, and elevates the role of partisanship in line drawing. It adds this burden that also, when states say it's partisanship, we have to produce new evidence in the form of an alternative map to show that they could have achieved their political goals without the harm to Black or other voters of color. These are all different burdens than we had before this decision, which are wrong, but they're ones we may have to contend with. But it by no means means that in certain circumstances people should not be bringing racial gerrymandering claims. And it also doesn't mean, because it's such a distinct claim, that Section 2 Voting Rights Act and or intentional discrimination claims might also be the more viable claims in other contexts.
Thank you, Leah. I do want to get to our amicus briefs, but before I do that, I want to bring Stuart back into this conversation and maybe sort of ask you both one question about the kind of combined impact of Calais and Alexander and how you're thinking about them kind of more generally. So, Stuart, if I could first ask you, these decisions obviously have a significant impact on voters in the jurisdictions where they're being decided. Louisiana with Calais, South Carolina with Alexander. What about more generally? How do decisions like Calais and Alexander affect voters in other jurisdictions?
Well, speaking about Calais in particular, I think if the district court's decision there, which struck down a map that was drawn to remedy discrimination that a federal court had identified, if that's allowed to stand, then we are going to see attacks on existing districts that were drawn to comply with Section 2 of the Voting Rights Act or with other provisions of the Voting Rights Act. We'll see those attacks going forward, not only in this cycle, but I think they'll be supercharged in the next cycle, the next redistricting cycle after 2030, when the states are all redrawing their districts again. There are many districts in the congressional map and in state legislative maps all around the country, really, that were drawn because of the protections that the Voting Rights Act offers. And, some of those were drawn a long time ago when the Supreme Court was not as stringent about what districts can look like, what kind of shapes they can take, how much they can bring in minority populations in different parts of the state into a single district. So I think we will see attacks on existing districts that were drawn to comply with the Voting Rights Act if a decision like Calais is allowed to stand. And we will need to defend those districts, but it'll be much harder if Calais survives Supreme Court review.
All right. Thank you, Stuart. And that's a good segue to the question I wanted to ask you, Leah, as you think about these two cases combined. How have legal strategies shifted from your perspective in light of Calais and Alexander? And what sorts of issues are you looking for as you think about other redistricting cases and other redistricting issues that are likely to unfold in the coming years and decades in light of these two decisions?
Bridging a little bit of what Stuart said, I mean, historically, we should just make very clear that these racial gerrymandering claims that were of the type that we brought in Alexander were, to Stuart's point, historically brought by white plaintiffs to challenge the majority minority VRA districts' ability to elect districts as being excessively race-based. And following the 2010 census, as legislators packed districts with too many Black voters, but without assessing whether or not the number of Black voters were needed in order to provide protections against dilution. They were just stuffing Black people into districts on the basis of race without doing the proper analysis. And similarly, they were cracking Black voters to levels below the necessary levels in order for them to be able to affect their ability to elect candidates of choice. And so that is how minority plaintiffs have come to use the racial gerrymandering theory in order to try to, in those limited circumstances, challenge packing and cracking schemes. That is, again, what we were trying to do in Alexander, where this was not about the failure of South Carolina to draw a second majority minority district, but it was their failure to use their own principles and, in fact, use race as a means to get their partisan goals by removing Black voters on the basis of race, not because of their party, but because of their race. And so if there are situations where that is happening, and we have a case pending now in Arkansas where similarly in the historic Pulaski County, which is home to Little Rock, which is where the most diverse county in all of Arkansas, in the southeast corner of the county, 14 significantly Black, heavily Black precincts were carved out, and Black voters were cracked amongst 3 congressional districts and we believe it was not targeting Democrats, but it was targeting Black voters as a means to effectuate that line drawing. And that another aspect of the point of the cracking was to dilute the heart of Black voting power, which is in that Pulaski County in one particular district. So we have that claim pending, and it is clearly made much harder, and we have new evidentiary burdens in light of Alexander. But again, those claims make sense in those conditions, but there may be other jurisdictions where we will pursue Voting Rights Act claims because they have discriminatory results. They harm the ability to elect Black voters, and or where we may have evidence that the design of the map was intentionally dilutive, and there may be an equal protection claim under the Arlington Heights in Section 2 theory. So this will all be very jurisdiction specific, and I think we as an organization are committed to using whatever tools are available in order to pursue racial discrimination, cognizant of, not making bad law, and cognizant of, the outcomes, the potential pitfalls of bringing some of these claims in particular jurisdictions. So I cannot say that the Alexander decision doesn't change the way that we might pursue things. But I think, again, we have to look to the facts, and we have to look at what happened in each jurisdiction to determine what is the best means to challenge the racial discrimination. And that has not changed despite Alexander's terrible decision.
Well, thank you very much, Leah and Stuart. Just one note for folks who may not be as familiar with the case law. You heard Leah talk about the Arlington Heights framework a few times, and the Arlington Heights framework is a framework that allows plaintiffs to show that a law that may not be racially discriminatory on the face of the law was nonetheless motivated by some kind of racial discrimination and has a discriminatory impact. So it has a number of factors that plaintiffs can look to, and it's a very important tool, as Leah described, in this context and in many other areas where LDF litigates. I want to thank Leah and Stuart again for joining us. These two cases that they've talked about are just a glimpse of the scope of work that LDF does to try to ensure that the redistricting process is fair, that maps are fair for Black communities, and that legislators do not discriminate against or target Black voters when they're creating these new maps. Discriminatory maps, which happen when LDF is not successful, or these are the kinds of maps that LDF needs to challenge because they're discriminatory, are a catalyst for oppressive legislation that targets communities of color and other vulnerable communities. But when diverse communities are fairly represented in the legislative process, quality of life improves for everyone. We at LDF are working toward a future where every voice is heard and where elected officials accurately represent the voices of all of our people. Before we leave the topic of voting rights, I want to encourage everyone who's listening today to do your part in protecting our democracy. Most importantly, that means go out and vote not only in national elections, of course, but also local elections. Local elections are tremendously important in shaping the democracy we live in. Encourage your friends and family to vote. If you know someone who needs help getting to the polls, help them get to the polls. Part of voting, of course, is being prepared to vote. And that means knowing the requirements in your state for casting a ballot. It means doing research on the different offices that are up for election. It means sharing that kind of information with your networks. LDF has a nonpartisan microsite with all of this kind of information that will really allow you to be best positioned to vote, which is the most fundamental first step in ensuring a fair democracy for all of us. We're going to shift gears now to discuss the amicus briefs that LDF filed in civil rights cases this term. And I'm going to ask Molly Kane, who is LDF's John Payton Appellate and Supreme Court Advocacy Fellow, to join me. Molly joined LDF in 2022. She works on issues concerning Supreme Court litigation, and she drafts amicus briefs and other appellate briefs in the Supreme Court, other federal courts of appeals, and state Supreme Courts. Molly also maintains an active docket of cases outside the appellate process, including a desegregation case, an economic justice case, and qualified immunity matters. Welcome, Molly.
Thank you, Sam. I'm so happy to be here today.
So, Molly, Trump versus Anderson was one of the more high-profile cases from the recent term, one that LDF filed an amicus brief in. Can you tell us a little bit about what Trump versus Anderson was about and why it was so important?
Yes, Trump v. Anderson was one of two big Supreme Court cases about former President Trump's actions surrounding the January 6, 2021 insurrection. In this case, the Supreme Court addressed whether Colorado could remove Mr. Trump from its presidential primary ballot. At the end of last year, the Colorado Supreme Court held that Mr. Trump was disqualified from holding the office of the president under Section 3 of the 14th Amendment due to his role in January 6. And thus, under Colorado's election code, he could not be on the state's presidential primary ballot, according to the Colorado Supreme Court. Now, Section 3 of the 14th Amendment is known as the Insurrection Clause, and it says that no person shall, among other things, hold any office under the United States or any other state if that person had previously sworn as a member of Congress or as an officer of the United States to support the U.S. Constitution, but then later engaged in insurrection or rebellion against the federal government. The Colorado Supreme Court held that Section 3 applied to former presidents because they are officers of the United States, and that Mr. Trump had violated Section 3 because of his actions, so the court held he could not hold an office of the United States, meaning that he is disqualified from being president. And then Colorado's election code prevents people who are not qualified for the office to be on the ballot for that office. And thus, under the state court code, the court held that Mr. Trump could not be on the ballot. Mr. Trump appealed this decision to the U.S. Supreme Court. LDF wrote an amicus brief supporting neither party that highlighted the importance of the 14th Amendment to the continuing existence of our constitutional democracy. Further, the brief asserted that the 14th Amendment's text and history prove that is unquestionably self-executing, which means that Congress does not need to do anything or pass legislation to make that amendment actionable in courts. The brief urged the court to ensure that Section 3 is fully enforced and that it unequivocally bars insurrectionists from holding federal office without any further action by Congress. But at the Supreme Court, the court reversed the Colorado Supreme Court's decision, holding that Colorado is not allowed to disqualify Mr. Trump from its presidential primary ballot under Section 3. The opinion was technically per curiam, which means it was technically unanimous, but really it was only unanimous in the outcome, since all justices agreed that Colorado can't kick Mr. Trump off the ballot, but it was not at all unanimous in the reasoning. So 5 justices formed the majority reasoning, and those justices were Roberts, Thomas, Alito, Gorsuch, and Kavanaugh. And they joined a far-reaching majority opinion that went well beyond the narrow question before the court and held that Section 3 is not self-executing, meaning this majority believes that Congress needed to do something before Section 3 can be actionable. And since Congress has not passed the executing legislation to allow courts to enforce Section 3 against people, the Colorado Supreme Court was wrong to do so. The court majority here ignored a basic principle of the role of our courts in constitutional structure, which is that courts should not decide more than they need to in order to resolve the questions before them. The court majority could have easily ruled for Mr. Trump on much narrower grounds, but instead it ignored well-settled law that the 14th Amendment is self-executing on its face. In a separate opinion, Justices Sotomayor, Kagan, and Jackson sharply criticized the majority for this overreach, and they fault the majority for attempting to insulate all alleged insurrectionists from future challenges to holding federal office. This separate opinion also made several points that LDF's amicus brief raised about Section 3 of the 14th Amendment. So overall, the court's majority opinion ignored the plain text and purpose of the 14th Amendment, and it effectively provided constitutional immunity to insurrectionists unless Congress passes legislation to make Section 3 actionable. And this opinion continues a disturbing and dangerous pattern of judicial overreach at a time of mounting threats to the rule of law and low public confidence in our judiciary.
Well, thank you very much for that analysis, Molly. And I wanted to underscore Molly's initial sort of framing that the LDF amicus brief was filed on behalf of neither party. LDF has a very, very strong interest in defending the Constitution and defending the rule of law. And that's what we focused on in our amicus brief. And as Molly described, what we think the concurring but really dissenting justices really picked up on in their opinion. So even though we're a nonpartisan organization and we don't get involved in anything to do with candidates, we all have a very strong interest in defending our democracy and defending the rule of law. And Molly also mentioned that there are 2 cases that the court decided involving former President Trump and his role in the insurrection. The other one, of course, being Trump versus United States, which involves the criminal prosecution of former President Trump for his role in the insurrection. And in that case, the Supreme Court, also over dissents by Justices Sotomayor, Jackson, and Kagan, and a partial concurrence by Justice Barrett, entered an opinion that gives a very broad immunity to former President Trump for his action that could potentially be considered official action. So to the degree he was doing anything that is linked to his powers as a president, the court made it extremely difficult for him to be held criminally accountable, even for criminal conduct. So that's the other significant decision that Molly referenced, having to do with former President Trump and issues related to his role in the insurrection. I'm going to turn now to ask you about a very different case, Muldrow versus City of St. Louis. This was a really important employment discrimination case. Can you tell us a little bit about that case, Molly?
Yes. So Muldrow is about whether Title VII plaintiffs who claim that their employers transferred them to a different position due to discrimination have to prove whether they suffered a materially significant disadvantage. So in this case, plaintiff Titania Muldrow is a sergeant with the St. Louis Police Department, and she argued that her employer transferred her from a job in the intelligence division to another job against her wishes because she is a woman. In fact, the new captain later testified that the man he replaced Muldrow with was a better fit for the intelligence department's very dangerous work. So in her new position, Sergeant Muldrow's rank and pay remained the same, but her responsibilities, perks, and schedule changed, as well as the status of her role. So Sergeant Muldrow brought a Title VII claim against her department for sex discrimination. So Title VII is a part of the Civil Rights Act of 1964, and it prohibits, among other things, employers from discriminating against individuals with respect to their compensation, terms, conditions, or privileges of their employment due to the employee's race, gender, religion, or national origin. So in this case, in the below proceedings, both the District Court and the Eighth Circuit Court of Appeals ruled against Sergeant Muldrow because the Eighth Circuit required that plaintiffs must show that the change in employment affected a significant change in working conditions, which produces a materially significant disadvantage. And both courts thought that the involuntary transfer that Sergeant Muldrow experienced didn't hit that heightened bar because the transfer did not result in a reduction of her title, salary, or benefits. So LDF wrote an amicus brief in this case, which argued that the materially significant disadvantage standard from the Eighth Circuit would allow discrimination in the workplace, so long as that discrimination isn't material. And that would undermine Title VII's goals of eliminating discrimination in the workplace, and it also trivializes the serious dignitary harms that result from discriminatory treatment. And since the heightened standard from the Eighth Circuit permits transfers if they are not a change in title, salary, or benefits, it would permit employers to maintain separate but equal workplaces, which undermines Brown v. Board of Education. So the Supreme Court agreed that the Eighth Circuit's materially significant disadvantage standard was antithetical to the text of Title VII and reversed the Eighth Circuit and ruled for Sergeant Muldrow. The court made clear that Title VII plaintiffs do not have to show that the harm incurred to them was significant. They just need to show that some harm occurred. This decision is an important victory for workers across the nation, and it ensures Title VII's protections against racial discrimination and sex discrimination are fairly applied. Contrary to what some have claimed, this decision does not directly implicate programs that advance diversity, equity, inclusion, and accessibility, otherwise known as DEIA programs, because unlike the discriminatory transfer at issue in Muldrow, DEIA programs generally do not rely on race or gender to determine the terms and conditions of employment.
Thank you, Molly. So some, much needed positive news from what was otherwise a pretty difficult term at the court. And the last cases I wanted to ask you about are the reproductive rights cases that LDF filed amicus briefs in. in the wake of the Supreme Court's Dobbs decision, which overturned a basic understanding of our constitutional jurisprudence that there is a constitutional right to abortion care. There have been so many new issues that have arisen as many states have enacted really draconian new laws and policies designed to prevent pregnant people from obtaining abortion care. And then there are also issues at the federal level in terms of access to certain medications. So could you tell us a little bit about the two significant abortion access cases that the court decided this term, and also kind of what the next steps are going to be with respect to both of those issues?
So this term was a stressful term because the court was supposed to decide two big reproductive rights cases, as Sam mentioned. One was on the legality of expanded access to the drug mifepristone, which is used in medication abortions. And the other one is about how much states can limit abortions in emergency situations. And since this is all 2 years after Dobbs, people were concerned that the court would make abortions even harder to access. However, this court actually did not decide the big legal issues in either case. So the court did not further restrict access for now. But this means that these issues will likely come back to the court sooner rather than later. And so we are not out of the woods yet on these issues. So turning to the first case, which is the Food and Drug Administration v. Alliance for Hippocratic Medicine, or how you have probably seen it, FDA versus AHM. This case is consolidated with another one, which is Danco Laboratories v. HAM. And this case is about mifepristone, which is a part of a two-step drug protocol for medication abortions. So a group of anti-abortion doctors and anti-abortion groups sued the FDA about both its initial approval of the drug mifepristone in 2000 and its later actions in 2016 and 2021, which changed the drug's conditions of use to expand access to mifepristone. The district court agreed with the anti-abortion plaintiffs and blocked the FDA's original approval of the drug, and thereby they ordered it off the market. And then the FDA and the drug's manufacturer asked the Supreme Court to keep mifepristone on the market while the case was being decided, which the court did. The case then went to the Fifth Circuit, which agreed with the district court about the FDA's 2016 and 2021 changes, meaning that it agreed that they were illegal, but it said that the plaintiffs could not sue about the original approval of the drug in 2000 because too many years had passed. LDF wrote an amicus brief in this case, which argued that blocking this expanded access of mifepristone would further impede equitable access to health care because, in part, inequities in access to abortion care further exacerbate existing racial disparities in access to comprehensive health care. And so then the case went back to the Supreme Court to discuss the issues of the 2016 and 2021 expanded actions about mifepristone. And the Supreme Court actually ended up not deciding that issue and instead held that the anti-abortion plaintiffs challenging the FDA's actions did not have standing to bring the suit, meaning they were not harmed enough jurisdictionally under the Constitution to bring a lawsuit on this issue. The court underscored that the plaintiffs here do not prescribe or use mifepristone, nor is the FDA requiring them to do or not do anything. Instead, the plaintiffs wanted to make mifepristone more difficult for other doctors to prescribe and for other people to use. As Justice Kavanaugh writes, under Article 3 of the Constitution, a plaintiff's desire to make a drug less available for others does not establish standing to sue. So basically that means these plaintiffs can't bring this lawsuit, which effectively ends the case. And that means that mifepristone will stay legal and broadly accessible in the states where it is not banned. But because the case was dismissed on standing grounds, it is possible for a future different set of plaintiffs who could argue they have injuries, could try to have standing to bring a different suit. And now there was also another case the court decided about agency actions and how long you had to sue them. And it changed the rules on how long you have to sue them. So it now is possible for a plaintiff to bring a suit about the initial approval of mifepristone, which would not be great for access to that drug. And then the second abortion case of the term is actually a consolidation of two cases, Moyle versus United States and Idaho versus United States. And this case is about whether the Emergency Medical Treatment and Labor Act, or EMTALA, preempts Idaho's Defense of Life Act, which prohibits abortions except when necessary to save the life of the pregnant person. So following the Supreme Court's opinion in Dobbs, Idaho enacted one of the most restrictive abortion bans in the country. And so the United States Department of Justice sued Idaho, saying that its strict anti-abortion law conflicts with EMTALA, a federal law that has required Medicare-funded hospitals to provide life-stabilizing care in emergency situations, including emergency abortion care, nationwide for decades. So the DOJ argued that EMTALA would require hospitals to provide abortions when the patient is experiencing an emergency medical condition, and abortion is the stabilizing treatment necessary to resolve that condition. For example, Idaho at oral argument indicated that its law would prevent abortions in cases where the pregnant person is not going to die, but failure to provide an abortion would risk that person's ability to carry children in the future or other major medical issues. And so the DOJ says that this restriction that Idaho claims it's allowed to do is an abortion. This restriction on abortion that Idaho claims it's allowed to do is against EMTALA. And so the district court enjoined Idaho's law to the extent that it conflicted with EMTALA. And then the case went back to the Supreme Court, which reinstated Idaho's abortion restrictions while the court took months to decide the case. LDF joined the National Women's Law Center's amicus brief, which explained that EMTALA protects access to all emergency medical treatment, including emergency abortion care. And so now the court holds that it made a mistake by intervening in the case too early, and thus it did this thing called dismissing the case as improvidently granted, which you may hear people call it dig the case. And this means the court is telling the lower courts to keep going with the case and to come back when the case is more developed. This ruling feels like a mixed bag because on one hand, a ruling saying that EMTALA does not preempt laws like Idaho's would be horrifying for pregnant people and also would allow states to deny pregnant people abortions when abortions would be necessary to protect their organs, their ability to carry children in the future, and other emergency stabilizing treatment. However, the court's decision to actually not decide anything right now is also deeply frustrating and harmful since the court let Idaho's law go into effect while the court waited until the end of the term to decide not to decide the case. And this has been devastating for pregnant people in Idaho in need of abortion care and has led to people having to get airlifted out of the state for necessary abortions. And also, people in Idaho are not the only ones needing clarity, as there are other states like Texas who have this exact same issue popping up. And so the court here had the opportunity to affirm abortion access, and it did not, and it left many people hanging in the balance. As Justice Jackson said in her dissent, the decision is not a victory for pregnant patients, it is delay.
Well, thank you very much, Molly. Thank you as well to Leah and Stuart for your earlier analyses. Thank you all for joining us today. Before we close, I want to make you all aware that we will be sending you a few additional resources in the coming days and weeks. In addition to a recording of this webinar, we will share LDF's annual SCOTUS Roundup, which has a written summary and analysis of key cases from the 2023-2024 term, including the cases that you heard about today, as well as some others. And then in the fall, we will be releasing an overview of key civil rights cases that we expect the court to be addressing in the 2024-2025 term. You can find these and other publications on our website and also on the website for LDF's Thurgood Marshall Institute, which is our internal strategic research hub. I would like to end by thanking all of you for supporting LDF and for your commitment to advancing racial justice. Thank you.
This concludes our webinar. Thank you for joining us today and for supporting the Legal Defense Fund. For the latest news, please follow us on social media.